It is a treatise that describes the history. It describes the markets, how they've evolved and how they exist today, to provide practical context and explanation for understanding then how the statutory framework under the CEA applies to the derivatives markets. The latest edition with a very impressive pedigree, with the initial treatise first published by Philip McBride Johnson back in 1982 as Commodities Regulation. So this is the fifth version, sort of carrying forward a significant, important treatise, bringing things to the present. A treatise that has value for both established practitioners in the area, but novices as well, who would like to understand the regulatory framework from a practical context.
Why did Phil McBride Johnson originally create this treatise?
I don't think we actually know the answer to that. He often told the story of writing the first edition on a beach in, I think, Bermuda. At that time, he was distinguished by being former chair of the CFTC, and also being at the very top of leadership of the industry. I think there was a yawning absence of a treatise to really give an overview and understanding of futures regulation. He was kind of ideally suited to do it, and he was a fantastic writer and liked to write. So there was a logic to it, but it was also inspired, I think. I'm actually impressed that far back he had the foresight to say, this is a need that needs to be filled to give practitioners and government regulators a real understanding of the workings of the market and of the regulatory history and current regulation. And I know I went to the CFTC in the mid to late 80s, and one of the first things I picked up was Phil Johnson's treatise to try to understand what was going on.
Who is the target audience for this resource?
Novices would benefit from it because it provides historical background on the markets, on the Commodity Exchange Act and the history of the CFTC. It is very comprehensive in terms of the legal issues addressed. Judges and their law clerks would use it to find arguments and analyses that might not be in the briefs they receive. Experienced practitioners would also use it. I think it goes to quite a bit of depth. There's many areas in commodities law, and the practitioners may not know them all, so it's a resource for them. I think in the area of the prohibitions and offenses of the CEA, Commodity Exchange Act, there's a lot of murkiness and debate and argumentation about what the scope of the offenses are and what the elements are. I think this treatise provides a lot of analysis on that regard and gets into more depth than just an overview and some of the regular repetitions or statements that people make about what the law means. Oftentimes, they really need more analysis to get to the heart of it.
The last edition was from 2004, I believe. So there's a lot that's new because there's a lot that's changed in the industry since then, but new also in terms of the structure and organization. We substantially reorganized the prior edition to, I think, be a more logical approach for understanding today's markets. And so there are sections that start the treatise to provide some initial context around sort of the basic statutory framework, the history, some basics around the markets, which is very useful. And then the treatise transitions into more detailed chapters on the CFTC, how it's structured, its relationship to other agencies, interplay between federal and state law and state preemption, then a chapter on sort of how registrants are regulated, looking at today's markets and industry, and then a separate chapter on market regulation, which also has a lot more discussion around clearing and the prominent role of centralized clearing today, especially post Dodd-Frank, along with some discussion around the commodity broker bankruptcy provisions.
The offenses chapter has been largely rewritten to cover both new precedents and new theories of law that the CFTC and the Department of Justice have brought forward, and new prohibitions such as spoofing that came in with Dodd-Frank. We have retained a significant amount of Phil's original work on some of the watershed cases under the Commodity Exchange Act, one of which Indiana Farm Bureau, he was a concurring author on when he was chair of the agency. But those watershed cases aren't talked about a whole lot anymore. We retained them because I think they still have a lot of insight, and sometimes courts do go back to them for guidance. And Phil's analysis of them was so thorough, there isn't another place in the literature where you can find that thoroughness. A section that goes into why you shouldn't indiscriminately apply securities law anti-fraud principles in the commodity markets, because the commodity markets work differently, and the law to some degree is also different. The substantive law is different from the securities laws, and that's something that I find today many courts look at the securities law principles and precedents and try to apply them as though they fit neatly into the Commodity Exchange Act. Sometimes they do, a number of times they don't, and this treatise does address that.
There has always been a lot of history in this treatise, and one of the, I guess, focus points of this new edition is to do a clear narrative of the CFTC, of the history of derivatives regulation in one place. It shows very long history and an amazing number of legislative sort of switchbacks from one vantage point to another, from free market to non-free market and everything in between. If I were a regulator, I'd want everybody to read that, or at least understand it in some way. So I think that is a good improvement in this edition.
Does the new edition express a specific viewpoint on derivatives regulation?
It doesn't really, and it wasn't intended to, but I think to some extent we all felt it was helpful where appropriate to maybe suggest some insights into the state of the particular area of regulation. So I think Phil Johnson set the standard there by being hugely insightful and creative in what he wrote about what was going on and had gone on. And we tried to preserve a lot of that discussion because it was so good. And I don't think any of us really ventured quite as far as Phil did, and I certainly did not feel that I could do that or wanted to do that. But I think there are parts where you will see that there is a suggestion of perhaps issues that are not being addressed that might be addressed.
I think there's a point of view as to how one should approach understanding the CEA and being thoughtful. And we keep talking about history as a theme, but to understand a lot of the provisions in the CEA today, you have to understand the historic context in which they arose. And so it's helpful to understand the historic context. I think there's a point of view around it is important to go back to the statute as the anchor. What does the statute say? What are the products that are regulated? What is the CFTC's authority and the scope of its authority, and that the words matter that are in the statute. So it does take, I think, a bit of a point of view on an analytic framework for thinking of the CEA as a practitioner and how the provisions apply to the markets and the industry.
By choice of focus, we do, implicitly at least suggest that there's some things that warrant attention that may be lost in the shuffle. Personally, focused to some extent on some of the ways of addressing systemic risks that have arisen in the course of the past few decades. And that's not a subject that probably gets enough attention, in my view. And so where I could, I tried to emphasize that.